The contract remedies question from February of 2002 is a challenging UCC problem. Here's a hypothetical that requires us to know a great deal about the rules of contract formation as well as remedies. Have a look at the call of the question. 1. What remedies are available to Borelli to enforce the terms of the contract with grower? What defenses might grower reasonably assert? And what is the likely outcome on each remedy sought by Borelli? Discuss. Well, obviously we're dealing with contracts and we're dealing with specific performance. So the elements of specific performance come to mind as we think about outlining this call of the question. But remember, in order to have a remedy, a party has got to have a theory of liability. And we know based on this call of the question that that theory of liability is going to arise out of contracts, which breaks down into formation, defenses to formation, etc. So although we're going to be focusing our attention particularly on remedies, we know that if the facts are present, we're going to talk about formation as well. Call of the question 2. If Borelli elects to forego enforcement of the contract and elects instead to go for damages, what defenses might grower reasonably assert, and what damages, if any, is Borelli likely to recover? Discuss. Well, once again, the focus is on remedies, but the plaintiff has to have a valid theory of liability first. Now, it's my theory, generally speaking, that the shorter fact patterns are more difficult than the longer ones. But this is a long, complicated question, and completing a good answer to this question under time constraints requires a particular discipline and a particular attention to detail. So let's go to the top of the question. We meet Borelli at the top of the fact pattern. We see that Borelli is a big buyer of tomatoes and that Borelli makes tomato-based pasta sauces. We also see that the taper tomato is an important part of this product. So the parties, plaintiff and defendant, agree at $100 per ton. So far, so good. It looks like a requirements contract, a UCC agreement between merchants. But read paragraph 2 with great care. Paragraph 2 is where we learn with a careful reading that maybe this isn't really a contract at all. Have a careful look at it. You see that it's a standard form contract that Borelli uses with all of its various growers. And it explains that carefully, at the end of the growing season in August, all tomatoes that Borelli might require, that looks like a requirements contract, but skip down to the end of the paragraph, and it reads, the contract also stated that Borelli could reject growers' tomatoes for any reason, even if they conform to the contract. Well, what has Borelli really agreed to here? Nothing. It doesn't look as if Borelli has really suffered any kind of a bargain for exchange, no detriment. It looks as if Borelli has all of the authority between these two parties. And as we look at the middle part of the paragraph, we see that things begin to look even worse for this plaintiff. How come? Because there's indicia of fraud. During the discussion, the representative of the grower points to a provision in the contract that deals with sales to third parties. It's banned under the agreement, and Borelli's representative explains that they never enforce it when, in fact, they always enforce it. And that's a material misrepresentation. That's enough to equal a fraud claim. And if grower were the plaintiff, grower might be entitled to punitive damages under these facts. But the call of the question is asking us all about Borelli. By the end of paragraph 2, we've got to be fairly suspicious about whether or not Borelli is going to be entitled to anything in court. In paragraph 3, we learn about the relationship between the parties, and it seems apparent that Borelli needs these tomatoes. But notice, in paragraph 3, we've got another buyer on the scene, a buyer who offers a higher price than Borelli, and the grower takes it. So it looks like a UCC contract. If we have a grower in breach, the preferred remedy would be damages under the UCC, and damages are fairly easy to calculate, you'd think. However, under these facts, we've got one of those exceptions to the specific performance rules under the UCC, and that is, there may not be enough tomatoes available from other growers because of problems with the crop. And if that's true, a successful plaintiff in Borelli's position would have a pretty good chance at getting specific performance. Next, in paragraph 4, we discover that Borelli is only able to cover for 10 tons of the tomatoes, and it can't get any more. And so the lawsuit arises, and we get the cause of the question once again. Well, there are a lot of details in this long hypothetical, and we've got to find a home for all of them in our answer. So turn the page with me, and please take a look at the outline of issues that I present. You'll see that most of my attention goes into the elements of specific performance. However, two important details are present. First, I spend a reasonable amount of time going through the motions to establish the contract. And it's a big deal here because ultimately I'm going to conclude there isn't really a contract here at all, and therefore the plaintiff fails to achieve anything that the plaintiff is seeking. So have a look at the way that I structure this part of the analysis. I'm not doing anything innovative here. I'm following my own approach. And a standard way of thinking about contracts. It's hardly my original idea. I talk about this being a UCC contract, and then I focus a little bit on formation. Next, defenses to formation. There's a clear breach if there is a contract at the time that grower repudiates the agreement. Then there are possible defenses to breach, and then, in the end, I conclude that the plaintiff loses. But I don't stop there. I go into the elements of specific performance, and before I do that, I touch on a little tested issue. At least, it's little tested on the essays. It does come up sometimes on the MBE, and that's replevin. Replevin looks an awful lot like an equitable remedy, but it isn't. It's a legal remedy, and sometimes in disputes between growers and food processors, replevin is relevant because it allows a plaintiff to obtain possession before trial. So I throw in a little bit about replevin because this is a remedies question arising out of the contracts context. And although replevin hardly is a pass-fail issue in this question, it is one issue to talk about that certainly can make our answer stand out as one authored by somebody who really understands remedies. Then I focus on the defenses to specific performance, and once again, I find for the defendant. Next, I talk about growers' defenses and Borelli's damages. Now that we're focusing on the regular UCC remedy of damages, as opposed to specific performance, but once again, I find that this is not a valid agreement, and so the plaintiff doesn't really have a leg to stand on, and certainly wins nothing in court by my analysis. Now, turn the page, and let's have a look at my answer briefly. Let's see how one might write about these issues in a way that makes sense, but is still economical enough that it realistically could be done under time constraints. Notice right up front that I am leading with the facts. I'm focusing on the parties and identifying the theory of liability. I don't get away from the basic structure of civil litigation. We've got to know who the parties are. We've got to know what the plaintiff's theory of liability is. Then we consider each element of that theory of liability and then turn to remedies. Clearly, this question is particularly interested in remedies, but they wouldn't have all these facts about formation in the pattern if we weren't supposed to find a home for them and analyze them as carefully as we analyze everything else in the question. So, up front I introduce the parties and the theory of liability. Next I turn to formation. I find a home for the details there. It is not elaborate. The analysis that I present is only a few short sentences, but I find a home for the facts, and I establish the foundation that the plaintiff is going to use, the UCC law between merchants. Next, I focus on defenses to formation, but here I allude to the analysis that's going to follow in the second section, which is really responsive to the facts of the question presented about the defenses of our defendant. So next I turn back to the plaintiff. I focus on the breach by the defendant, the repudiation on the 15th of August. In those paragraphs, again, nothing very long, but quite detailed and focused on both the facts and the legal implications of those facts. Remember, we're not trying to copy the law. We're not trying to just recite the facts. We're trying to show a disinterested bureaucrat that we know the law and that we know where the law and the facts touch. Next, I focus on defenses to breach. And I also explain that commercial impracticability could also be a defense to breach. Finally, I conclude that although arguably it's a close call, I find in favor of the defendant. Next, we turn to Borelli's remedies. And here you'll notice under replevin that I do take the time to define it with a reasonable amount of care. I'm the guy who's always telling you, strip the definitions to the bare minimum. But here, replevin is a sufficiently subtle and a sufficiently rare issue that I actually take the time to explain what the law is. Now, I only do it in a couple of sentences, but they are fairly complicated and factually specific sentences about how replevin would apply to these parties. And I indicate that if Borelli were able to establish a breach of contract claim, Borelli might actually have a very good claim for replevin. Now, suppose you looked at these facts and you conclude exactly the opposite to the way that I do. Suppose you look at these facts and you say, well, the contract language may not be very good, but this is the UCC. We can be a little bit loose about these things. The parties appear to have reached a binding agreement, and we've got a repudiation by grower. Okay, well, I don't agree with that analysis, but I can't say flatly that it's wrong. Certainly there are facts here that could be used to justify and support that argument. So, next I turn to the specific performance remedy, and I go right through the elements of specific performance. It's quite simple and straightforward. And again, I don't waste a great deal of time on it, but I do cover the bases and particularly with regard to mutuality. I'm not terribly important element, typically, but in this case, the facts really do go to mutuality, since part of my theory of the case is that the plaintiff hasn't really established a valid contract. So, in the end, I conclude in favor of the defendant. You might well reach the opposite conclusion using the same facts. Next, I turn to Grower's defenses and Borelli's damages, once we've dealt with the enforcement issue in the first section. Here, I lead with the details because, aside from the technical analysis about whether or not this is an enforceable agreement based on the failure of consideration, I just don't like Borelli because they engaged in fraud in the negotiations. Now, obviously, this is not a torts question, and clearly we're not being asked about Grower's potential remedies. But Grower wants out of this contract, and Grower doesn't want to be liable for damages. And I find that the fraud analysis offers a pretty compelling defense from Grower's point of view to avoid having any remedies being applied. Notice that I also I refer to failure of consideration and also to unconscionability, all as separate justifications for allowing this defendant to escape any liability for damages, as well as specific performance liability. Finally, I turn to damages, and I explain what those damages are. Once again, the State Bar is not testing our ability to do math, but I'm sufficiently sharp at least with round numbers, that I'm able to do the math and include the results in the analysis. My bottom line, Grower wins, plaintiff loses, and the result is Grower gets to sell this crop to the higher bidder, and Borelli basically has to go and whistle.